The next important aspect regarding the Constitution of India is the ordinance making power of president or otherwise it could be considered as the legislative power of the president or the lawmaking power of president as provided under article 123 of the Constitution. So, we'll discuss the very clause 1 of Article 123 regarding the promulgation of ordinances during the recess of Parliament. So, in that connection, the constitutional provision as per clause 1 is that if at any time except when both houses of parliament are in session, the president is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinances as the circumstances appears to him to require. So, in that connection, we will discuss one important leading case, that is Nagraj versus State of Andhra Pradesh, and it was a case of 1985 decided by the Supreme Court, where it was pronounced that this article is intended to enable the president to promulgate ordinances during the recess of parliament. The president's power is no higher and no lower than that of the lawmaking power of the parliament. The satisfaction of the president must be as to the existence of circumstances which render it necessary for him to take immediate action, and such satisfaction has to be on the advice of the cabinet as it was pronounced by our Supreme Court in this leading case, Nagraj versus State of Andhra Pradesh. So now we will discuss regarding the provisions under clause 2 of Article 123, as it says that those ordinances promulgated by the president which have same force and effect as an act of parliament, and it should be within 6 weeks from the reassembly of parliament must be ratified, or it ceases to operate, or it may be withdrawn at any time. So the very provision relating to clause 2 of Article 123 is that an ordinance promulgated under this article shall have the same force and effect as an act of parliament, but every such ordinance shall be laid before both houses of parliament and shall cease to operate at the expiration of 6 weeks from the reassembly of parliament, or if before the expiration of that period resolutions disapproving it are passed by both houses upon the passing of the second of those resolutions, or it may be withdrawn at any time by the president. So, now we'll discuss the provisions of clause 3 of Article 123, which expresses about ordinance shall be void if it beyond parliament's lawmaking power as provided under the Constitution of India. So, the very constitutional provision is that if and so far as an ordinance under this article makes any provision which Parliament would not under the Constitution be competent to enact, then it shall be void. And now another thing is to be discussed that the very provisions of clause 4 of Article 123 are omitted under the 44th Constitutional Amendment Act of 1978. So now we'll discuss certain important leading cases such as Dr. D.C. Wada versus State of Bihar 1987, and this particular important leading case is relating to re-promulgation of ordinances where Supreme Court announced that while no case has gone to the Supreme Court regarding re-promulgation of ordinances by the Union, notice must be taken of the Supreme Court judgment holding that successive re-promulgation of ordinances with the same text by the Governor of Bihar without any attempt to get the bills passed by the State Assembly while it was in session, coupled with the habitual practice of proroguing the Assembly merely in order to enable the Governor to re-promulgate an ordinance in a routine manner would be a fraud on the Constitution, and the ordinance so re-promulgated is liable to be struck down. So, the very pronouncement of Supreme Court judgment in Dr. D.C. Wada versus State of Bihar in 1987 questioned the power of governor for re-promulgation of ordinance which, according to their lordship, if it would be an habitual practice of proroguing the assembly only for the very purpose to re-promulgate an ordinance, and if it is continued in a routine manner, then it would be a fraud on the Constitution. So, the Supreme Court could struck down any such re-promulgation of ordinance. And in another important leading case, the very effect of promulgation of ordinance is pronounced by the Supreme Court, and that is Nagraj versus State of Andhra Pradesh in 1985. And as such, the very lawmaking power of the President, the lawmaking power of the Parliament and fundamental and its relation with fundamental rights, so also distribution of legislative powers between the Union and the states are being pronounced clearly by their lordship of Supreme Court in 1985 in Nagaraj versus State of Andhra Pradesh in these words as pointed out above. The law-making power of the President is coexistence as regards all matters except duration with the law-making power of Parliament. It follows that the power is subject to constitutional provisions, particularly those regarding fundamental rights in respect of the subject matter of ordinance. The position is the same as applies to Parliament under the constitutional scheme of distribution of legislative powers between the Union and the states as it was pronounced by their lordship in this very important leading case, Nagaraj versus State of Andhra Pradesh. So, in our next upcoming video, we would like to discuss some leftover questions and answers relating to law